Yesterday, the High Court ruled that regulations promulgated in terms of Section 27 of the Disaster Management Act were unconstitutional and invalid. Stanley Malematja from the Centre for Applied Legal Studies joins me on the line. Thanks so much for your time on SABC News. In the simplest possible terms, what did that ruling mean?
Hi, Zinga. Thank you for having me, and good day to the viewers. What this judgment means, to us, it reminds us that South Africa is a constitutional state governed by the rule of law, meaning that the government does not have, the carte blanche to impose laws, and that it is, impose laws that are irrational, and that it is subject to the Constitution. And that, when government imposes or promulgates laws, is that, it must ensure that the steps taken or that law that is promulgated to achieve a permissible objective, it must be both rational and it must be rationally be connected to that objective. And I think, it is important to remind the viewers that, when the state invokes a national state of disaster in terms of the Disaster Management Act, it places the power to promulgate and direct substantial aspects of everyday life of people of South Africa in the hands of a single minister with little or none of the customary parliamentary or other oversight functions, and that this type of conduct must be closely scrutinized to ensure the legality and the constitutional compliance of the law that we are subjected to.
Okay, Stanley, it's not the lockdown regulations in their entirety that have been found to be constitutional. Which ones were found to be unconstitutional and why? The court listed a couple of provisions in the regulations which are constitutionally compliant. For example, the prohibition on initiation schools and the prohibition on the opening of schools and night vigils and funerals and so forth. The other provisions that were found to be unconstitutional is that when the court applied Section 36 of the Constitution, the limitation clause, it could not find that those particular provisions to be justifiable, the limitations on the rights to be justifiable in an open and democratic society based on human dignity and freedom. But what the court did acknowledge is that, in declaring this national state of disaster, the government took a rational decision, but certain provisions in the lockdown regulations, particularly level 4 and level 3, were found to be, constitutionally incompliant. Okay. What does the government have to do, according to court, to amend this?
In South Africa, we have what we call the separation of powers, meaning even if, a court gives an order, it cannot really direct and explicitly say what the government must do. So government has been given 14 days to remedy the defects to ensure that they are in line with they are in line with the limitations clause in the Constitution. So the limitations of separation of powers allows government to be independent and also not to for the court not to have like an overreaching into deciding what laws should state and how government should go about those laws. But the function of the court is to test the constitutionality of those laws.
So, Stanley, what happens sometimes when news comes out is that there's a headline grabbing things like unconstitutional and invalid, and then people may assume that their behaviors are allowed to change. Speak to us about if this changes anything in terms of how people living in South Africa must act around lockdown regulations.
The court was very clear in the in its judgment. Although certain provisions of the regulations were found to be unconstitutional and invalid,
the fact that, government is given 14 days to remedy the defects, it still means that the lockdown regulations still stand and they still apply. So particularly nothing has really materially changed until government can act on the defective regulations. So what it means is that what it means is that people can now say that we can start doing things that we were doing when life was normal. We can start gathering and having social gatherings and so forth. Those are still prohibited until that 14 days lapses and until government acts according to the court order.
Okay, so some legal commentators have lambasted this judgment, in part because it says that the court cannot decide that all regulations are irrational and invalid because some of them are irrational and invalid. I'm reading from Pierre de Vos's Constitutionally Speaking here. And then it says that when it comes to rationality, the court also erred. And lastly, in considering whether any of the regulations unjustifiably limits one or more of the rights protected in the Bill of Rights, the court failed to provide any argument on which regulations might limit which rights, and I'm reading that verbatim. Is that kind of criticism of the judgment founded?
In my opinion, I don't think that criticism is founded. When the court engaged in the rationality test, it also linked the rationality test to the limitation clause. And in that linking, the court said if a measure is not rationally connected to the permissible objective, then the lack of rationality would result in such a measure not constituting a permissible limitation. So here we are talking about, laws that, limited a lot of, constitutionally guaranteed rights, the right to life, the right to freedom of movement. And also, and the court has went in to talk about, give examples of few practical examples, where it says that the regulations that we are governed by, for in example, a person who runs a hair salon, is now told that he or she cannot run that business while watching her children suffer. At the same time, watching a taxi pass by with people in it or passengers sitting in close proximity to each other than they would have been in a salon. And also the court has, went further to give practical examples that this orders, the regulations rather, have also turned society into clients of politicians. Society has now become, at the mercy of politicians in terms of food parcels and so. So here we're talking about, real life events. Here we're talking about a situation where a person cannot, afford or is not allowed to make a living, but rather be subjected to food parcels, which are held by politicians.
Thanks so much for your time on SABC News this afternoon. Stanley Malematja from the Center of Applied Legal Studies joining me on the line.